Nimisha.
Hi, I'm Kelsey.
Hi, I'm Egypt.
Next patient, please. Mr. Bolam.
Good morning, Mr. Bolam. What is your issue today?
I feel sad.
Have you been having any suicidal thoughts?
All the time.
Have you been feeling empty?
Very.
Mr. Bolam, I think your depression has relapsed.
What should I do about it, doctor?
I think we need to administer electroconvulsive therapy. Nurse, therapy, but we won't be administering a relaxing drug or having any manual restraints. Please start your procedure.
Mr. Bolam?
Good morning, Bolam. What can I do for you today?
I would like to sue the foreign hospital for fracturing my hips.
Well, it is possible that we can bring them to court. We'll be able to prove their negligence and that they have breached their duty of care by not administrating relaxants for you.
Good morning, Dr. Gui. What can I do for you today?
So, a patient of mine named Bolam was going through electroconvulsive therapy and fractured his hips.
Okay. How exactly did this happen?
So, we did not administer a relaxing drug or have any manual restraints on him.
And why did you choose this mode of practice?
Because the patient is less likely to harm themselves.
Okay, so what we have to do now is we need to find an expert witness, a licensed medical practitioner, who will take the stand in court and say that he agrees with the conduct that you carried out in your procedure.
I would have done what Dr. Gui did as well. I would not have administered relaxants or restrained the patient because it might harm him even more.
The test for determining the standard of care owed by medical professionals to their patients is referred to as the Bolam test. The professional will not be in breach of their duty of care if they acted in a manner which was in accordance with the practices accepted by a responsible medical body. If this is established, it does not matter that there are others with expertise who would disagree with the practice. To sum up the case, a doctor is not negligent if he is acting in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art, merely because there is a body of such opinion that takes a contrary view.
By definition, negligence means nothing else but carelessness. However, under the legal sense, it is judged according to a reasonable man in the same situation. It means that there is a legal obligation to consider when it is foreseeable that the failure to do so can cause harm. And to determine whether or not there was a breach of duty, we can take a look at the case of Lye v. Birmingham Waterworks Co. The judges held that a breach occurs when the defendant fails to do something which a reasonable man, gathered upon those considerations which ordinarily regulates the conduct of human affairs, would do. And to test whether a person or not was reasonable, we can take a look at the reasonable man's test. It is an objective test in which the behavior of the defendant is compared with the behavior of an ordinary man in the ordinary circumstances. Or to put it simply, what would a reasonable man have done in the same situation? The definition of a reasonable man was described as the man on the street or the man on the Clapham omnibus in Halls vs. Brooklands Auto Racing Club. In Glasgow Corp vs. Muir, it was described as a perfectly average person. This is important because it ensures certainty and fairness by telling people without ambiguity the standard that they are supposed to adhere to. One cannot expect people to act in an extraordinary manner because it does not include personal characteristics.
There are different standards of care for different professions. Firstly, motorists. The standard of care is that of a reasonable driver. Whether the driver is highly experienced, newly qualified, or even just a learner driver is not relevant. This was further emphasized by Maggot LJ in Nuttaship against Weston, where he stated that the standard of care required by law is the standard of the competent and experienced driver. However, the standard of care of a driver can be lowered, provided that he or she is suffering from disability. For example, in the case of Mansfield against Weetabix, the defendant went into a hypoglycemic state when he was driving, so he was not subjected to the standard of care of a reasonably competent driver because he had no control over his actions.
The standard of care required for a child defendant is the foresight of a child of the same age. For example, in Mullins against Richard, two 15-year-old girls were fencing with a plastic ruler when it snapped and flew into the eye of the plaintiff. This resulted in her losing her sight. However, the courts decided that the defendant will not be held liable because, unlike an adult, two 15-year-old girls could not have been expected to foresee the risk of their actions. The exception to this rule is when the child is carrying out adult activities. For example, in Tucker against Tucker, because the child was driving, which is an adult activity, the child was held to the standard of care as that of a reasonable adult.
Lastly, many cases involving special skill concerns medical negligence. The defendant should be compared with a reasonable person of the same specialism and status. As said, a general practitioner is not judged by the same standard as a consultant cardiologist, as they have different standards on how they work. It is required that the defendant has acted in a way that will be supported by a body of respectable medical opinion. However, this has been criticized as they feel that this test allows the medical profession, to some extent, to determine appropriate standards for itself.
The law before Bolam can be seen in a Scottish case called Hunter against Haley. This case laid down the classic test for medical negligence. So the facts of the case are, Henley was given an injection but suffered an injury where the hypodermic needle broke. She argued that Hunter failed to exercise the standard of care and competence required by his duty in giving the injection. This was based on the grounds that the needle was not suitable for that type of injection, because if it was suitable, it would not have broken. Lord Clyde stated that to establish a liability by a doctor where deviation from normal practice is alleged, there are three factors that need to be established. Firstly, it must be proven that there is unusual and normal practice. Secondly, it must be proven that the defendant does not adopt that practice. And lastly, which is the most important factor, it must be established that the course the doctor adopted is one which no professional man of ordinary skill would have taken if he had acted with an ordinary man. Therefore, similar to Bolam, Hunter against Henley was a medical negligence case which extended the application of the principles to required standard of care to other professions, for example, engineers.
So the development of Bolam's test in UK and Malaysia is different. In UK, the Bolam's test first established in the Bolam's case, where Justice McNair stated that a doctor is not guilty of negligence if he has acted in accordance with practice accepted as proper by a responsible body of medical men skilled in that particular art, even if there is a body of opinion that takes a contrary view. This has then become a key test for breach of professional duty, but due to its paternalistic nature, it has caused many controversies in determining whether it is suitable to be applied to disclosure of risk. The first sign of judicial dissatisfaction with the Bolam's test appeared in Sidaway's case, where the House of Lords held that the defendant was not liable as the defendant had acted in accordance to the accepted medical practice, although he did not disclose the risk to the plaintiff. Lord Scarman dissented on the applicability of the Bolam test in this case and argued that disclosure was necessary because it reflects a basic human right. Lord Scarman's dissent has then become a basis for many court decisions which abandoned the Bolam test. In Pierce's case, the court departed from the Bolam test in their decision, and Lord Booth emphasized that disclosure of risk was not a matter of medical judgment, but it had to be based on what a reasonable patient would want to know. Here we can start to see the theme of reasonableness emerge, and the English law started to shift favorably towards the patients. Besides that, in Chester and Afshaw's case, Lord Steyn suggested that in modern law, medical paternalism no longer rules, and patients have rights to be informed of any risks as a result of surgery. Lord Steyn also emphasized that the court is the final arbiter of what constitutes informed consent. Finally, in Montgomery's case, the Bolam's test was rejected on the issue of consent and replaced with a test which assessed the risks involved from a reasonable person in the patient's position instead of referring to the accepted medical practice. Therefore, doctors are now obliged to reasonable care to ensure that the patient is aware of any material risks involved in any treatments.
The Bolam test was first introduced in Malaysia in the case of Chin Kiao v. Government of Malaysia. And in this case, the Privy Council at the time overruled the decision of the Federal Court and held that the defendant was indeed liable. This is because the patient's card had clearly stated that she was allergic to penicillin, and it was held that any respectable body of medical profession would not have acted the way that this doctor had, and this cemented the case of Bolam in Malaysia. Besides that, in the case of Elizabeth Chu v. Government of Malaysia, Justice Raja Aslan Shah held that the defendant would not be deemed liable as long as he had acted in accordance and followed the proper standard of medical care. And this was adopted in the case of Kamalan Rahman v. Eastern Plantation Agency, where the courts focused more on whether there was conformity to the standard of reasonable care that is deemed by the law and not by acceptable bodies of medical opinions. Thus, the courts will evaluate the opinions of medical professionals and determine the standard of care for medical practitioners in a medical negligence suit.
There are a few advantages of the Bolam test. Firstly, certainty. It sets out a clear standard that doctors have to adhere to. Secondly, the Bolam test ensures uniformity because all medical professionals are held to the same consistent standards. Decisions made in courts will be fair and consistent because the Bolam test will be used in all medical negligence cases. Thirdly, it protects the relationship between doctors and patients. Patients know that doctors are legally obliged to act in accordance to the set standards set for them. Doctors can do their job better because legal liability is not absolute.
In addition, another advantage of the Bolam's test is the absence of defensive medication. Defensive medication is the practice of recommending a medical treatment that is legally safe but not necessarily effective for the patient. This may seem beneficial to the patient because he is getting a thorough checkup, but instead it is beneficial to the doctor. An example in real life is the doctor puts the patient through multiple tests to prevent misdiagnosis so that the doctor can avoid liability. Moreover, defensive medication is expensive as it increases the cost of healthcare to patients and exposes patients to unnecessary risk. The Bolam test prevents doctors from opting defensive medication by providing a responsible medical body to justify the acts of doctors. This helps to encourage doctors to perform their job to their best ability.
Another important advantage of the Bolam test is the defense of therapeutic privilege. Therapeutic privilege is the non-disclosure of information to the patient because the information might be detrimental to the patient's recovery. This is often argued as an infringement of the patient's right to truth about his or her medical condition. However, the doctor does this with the patient's best interest in mind because before the doctor decides whether to disclose or not to disclose the information to the patient, the doctor looks at the clinical records of the patient. Factors that the doctor considers are such as what is the medical condition that the patient is suffering from and whether the disclosure of the information might hinder the patient's recovery or cause unnecessary stress or anxiety. Therefore, the Bolam test provides a defense of therapeutic privilege to the doctors because doctors have been unfairly sued for withholding information that may be detrimental to the patient's recovery. This was illustrated in the case of Sidaway. Lord Scarman referred to therapeutic privilege as justifying non-disclosure of treatment information in circumstances where the doctor reasonably believes that the disclosure of risk would be damaging to the patient or contrary to her best interests.
The first disadvantage of Bolam's test is that justice is rarely achieved for the victims. The Bolam's test doesn't have particularly high standards, making it easy to be fulfilled. You merely need your conduct to be supported by other medical professionals. And majority consensus or consensus from a certified medical body to fulfill the requirements are not required. Basically, it is too easy for doctors to evade negligence. Such was the case in Baker and others against Cambridgeshire and Peterborough NHS Foundation Trust 2015.
Because Bolam's test plays a cloak of protection around medical professionals, it makes it very difficult for claimants to pursue legal action. This obviously is very unfair, but is made even worse when you realize that this is in breach of one of the equitable principles, that is ubi jus ibi remedium. Where there is a right, there is a remedy.
The Bolam's test is also deemed to have given medical practitioners a higher level of immunity compared to legal professionals. The field of law is constantly developing, and lawyers are expected to update their knowledge regarding these developments to ensure that they are able to advise, advocate, and solicit with the latest legal principles. Similarly, in medical science, doctors are also expected to do so in order to provide advice, treatment, and diagnosis in their patients' best interests. In cases where doctors and lawyers have been negligent in their duties, it could at worst lead to the death of patients or death by punishment. Despite the serious harm that can be caused by negligence in both professions, the level of immunity for doctors is higher than lawyers due to the Bolam's test. As long as there is a body of medical opinion supporting the act or omission of a medical practitioner, regardless of the size of its supporters, doctors are not to be found negligent. Contrastingly, lawyers in Malaysia are obligated to the duty of care outlined in the Legal Profession Act 1976, and Justice Gopal Sri Ram was quoted saying that advocates here have never enjoyed immunity from suits for negligence in Lim So Wah and another against Wong Sin Chong and another. This is similar in the United Kingdom, where the 200-year-old immunity of negligence for lawyers have been overruled by the House of Lords during the case of Hall against Simons. Lord Hoffman recognized that English law provides a remedy in damages for a person who has suffered injury as a result of professional negligence. In other words, lawyers are not immune to negligent suits by their clients in both jurisdictions. Hence, why should only doctors be given such high levels of immunity when it is denied for lawyers? This seems to suggest that doctors and medical bodies are above the law.
Moreover, Bolam's test blurs the line of responsibility between the courts and hospitals. It creates a self-regulatory system in the sense that medical professionals are the ones deciding the standard of care that they should be held to. This problem is further exacerbated when you consider that a lot of doctors are hesitant to go on record officially stating that their medical opinion differs from their colleagues or other doctors. In this sense, we think it dilutes the role of judges in courts, as it prevents judges from using their own logical reasoning and their knowledge of the legal system to set a yardstick for the standard that they believe should be upheld in court. We think that the more reasonable test would be the test set out in Bolitho, which is an extension of Bolam's test, including the fact that judges will be able to decide for themselves whether or not the medical opinion had logical basis. This was the case in Reynolds against Tyneside Health Authority, where it was held that the opinion of the medical professional lacked logical basis. The courts were able to use Bolitho test in this circumstance to ensure that the claimant got the proper compensation they deserved. Christopher, in his paper Bolam and Bolitho, talked about how Bolam's test was created during a time where the word of doctors was held to be the final authority. He thinks that Bolam's test should not apply now, given the abundance of resources and the changes in society's needs and wants.
The question here is, how relevant is the Bolam's test in the UK today? Late in 1997, Lord Brown in the Bolitho case held that it is ultimately the courts who are the arbiters of what constitutes reasonable care. Doctors cannot be judges in their own cause. However, Lord Wolf said that judges were now less willing to allow the medical profession to determine what amounted to negligent practice. In the Bolito case, it was no longer enough for a doctor to produce evidence that a practice was accepted within the profession. Medical opinion now had to withstand logical analysis. In the case of Bolito, the court held that a doctor could be liable for negligence despite being supported by a body of professional opinion. If the court is satisfied, it was not reasonable. The court rejected the view of the Bolam test in this case. In the case of Reynolds versus North Tyneside, Justice Gross comments that it is one of those rare cases where the court should conclude that such body of opinion was unreasonable. Similarly, in the case of Merritt versus West Midlands, the Court of Appeal stated that the expert evidence given by the witnesses defending the doctor's conduct could not be logically supported. According to W. Scott's article, it will become increasingly difficult for doctors to justify their actions on the basis of producing colleagues who will say that they would have done the same.
So, to what extent is Bolam and Bolito still relevant in the UK today? In a past examination of case laws post-Bolito, McLean found that courts were still more inclined to follow the standards of Bolam. However, he had concluded that Bolito's influence had been widespread across the courtroom even though it has never been openly acknowledged. In the recent case of Reynolds v. North Tyneside, the judges followed Bolito and held that an expert testimony that supported a practice without logical basis could not be defended. In another case of Hunt v. NHS Litigation Authority, it was proven that Bolams will also be appropriate in the examination given by a doctor and the diagnosis received from it. In the final case of Ryan v. East London, failing to take proper account of technical information which leads to the mistreatment is also falling below the appropriate standard of care if a competent body of medical opinion would have reacted to the information differently. Thus, this proves that the Bolam's test is still being used in the UK today and that, in many instances, professional opinions will remain high and influential.
However, Bolito society has undergone a change with a more educated and informed public. It is difficult to imagine a fair and just system of medical litigation which does not apply the Bolam type test, and that makes it difficult to eliminate. Bolito represents an opportunity for the courts to apply a healthy check and balance to the vulnerabilities of Bolam and to ensure that it is not used to legitimize unsound practices of patient treatments. In order to reach its own conclusion on the reasonableness of clinical conduct, the court will arbitrate on the standard in each case, which would be a requirement to justify this on a logical basis. According to Legal Standard of Care, a shift from the Bolam test by Ash and Joe Samantha's article, this would enable the court to utilize the Bolito principle more proactively in setting the expected standard of care required by doctors. In other words, it may no longer be sufficient for a practitioner's action to be Bolam defensive. The court would seek to determine whether such action is Bolito justifiable. The traditional Bolam test is unlikely to survive its basic form.
In conclusion, according to Harvey Taft's article, the Court of Appeal in Bolito has made it clear that conformity with accepted practice was not by itself conclusive. Although there remains a strong argument for doing away with Bolam, causation will continue to play a decisive role in many cases. However, Lord Brown stated that the courts have only questioned reasonable and responsible medical opinion in a very small amount of cases, and it seems as though the Bolito approach is, as Mason and Laurie commented, a mere backup if the judges wishes to find for the claimant. Whilst the courts have slowly begun to depart from the traditional approach, more needs to be done before there is any comparison with the approach of other Commonwealth jurisdictions, such as Australia.
In Malaysia, the Bolam's test was first overruled in 2006 by the Federal Court, the highest court in Malaysia, in the case of Fu Fiona. They held that the Bolam's test, which had been the basis of medical negligence in Malaysia since its independence in 1957, was no longer applicable. In 2007, in the case following Fu Fiona, the case of Dominic Putucherry, the court held on the basis of stare decisis that the test in Fu Fiona would be applied and not Bolam's test. This was in relation to a misdiagnosis and mistreatment of a patient. In the case of Hassan Datullah against Kerajaan Malaysia, the courts held, following the decision in Dominic Putucherry, that the Rogers against Whittaker test would apply not only to misdiagnosis or advice, but to treatment as well. The Court of Appeal here confirmed that Bolam's test was no longer applicable in Malaysia for any types of medical negligence cases. Most recently in Malaysia, in 2017, in the case of Zul Hasnimar Hassan Basri against Dr. Kupu Velumani, the federal court held that the test applied in Rogers against Whittaker would also apply in Malaysia when it came to advice for treatment. However, the Bolam's test regained its place and would be used in cases pertaining to misdiagnosis and mistreatment of a patient. Currently, right now, Malaysia uses two tests side by side to ensure equal justice for everyone and to ensure that doctors are held to a proper medical standard to protect patients.
In a public lecture entitled The Standard of Care in Medical Practices, Has the Pendulum Swung Too Far in Favor of the Patients, delivered by Professor Dennis Cusack of the School of Medicine and Medical Science, University College of Dublin, Ireland in Kuala Lumpur, Dr. Cusack was of the opinion that the pendulum has swung from a doctor-centered test of disclosure of risk to a patient-centered test. But has the pendulum swung too far in favor of the patient, or has it merely swung to a point where the imbalance in favor of the doctor has now been properly corrected in favor of the patient's legitimate rights? Has the swing been too extreme, giving rise to the danger of defensive medicine being practiced by a litigation-nervous medical profession?
In conclusion, it can be said that the Bolam's test is still very much relevant in both UK and Malaysia, even though its application is not as significant compared to last time. This is because the court has said that they were the ones who should evaluate medical opinions and set the standard of care on medical negligence, which has expanded with the case of Bonito. This gives the opportunity to balance out vulnerability from Bolam. In Malaysia, however, the Bolam's test is applied differently, as it was first questioned in the case of Fu Fiona. They now differentiate the use of Bolam and apply it for treatment and diagnosis, and the case of Roger V. Whittaker is set as a basis for medical advice. Therefore, we can conclude that the Bolam's test is still very much applicable in Malaysia.